Today we are going to discuss two important theories in positive school of jurisprudence or analytical school of jurisprudence. Austin's command theory and Kelson's pure theory of law. So according to Austin, law is the command of sovereign backed by sanction. This is the theory, this is the definition given by Austin to the term law. So according to him, this law is actually the command of sovereign, and that is obeyed by the people. Okay, so the sovereign, three terms, we can see three terms in his from his definition of law. The first one is there should be a command, and that command given by a sovereign, and that has backed by sanction. That is, a sanction is behind it. So three terms. The first one is command, and second one is that is given by a sovereign authority, and the third one is a sanction behind it. So when we talk about command is a desire or vision expressed by a sovereign authority. So this command is actually an order. That was the important aspect of this theory of Austin. That he's trying to say that law is a command. Command means an order. That is not in the form of suggestion. That is not in the form of a permission is given. It is absolutely an order. That is an order should be obeyed by the people or the people under this sovereign. So this sovereign has the ultimate control over the people. So this sovereign actually given an order, whether it is moral or immoral. That is law. So this is the concept of the theory of sovereign as command theory of Austin. And when we talk about the sovereign means the person or body of persons having the authority, supreme authority. So that is what he tried to explain about sovereign. So this sovereign given an order, that is law. Okay. Another point he has given is that a sanction behind it, that is an order given by a sovereign backed by sanction. So what is sanction? So it is punishment. So people has to obey the order of sovereign because of punishment, because they fear about the punishments. So because of this fear, people obey the command of sovereign. That is law. This was the concept of Austin. And when we talk about the criticisms leveled against the theory of Austin, the most important criticisms, that is, the first one is use of the word command. It is not proper. It's not practical in modern world. In modern world, there are other forms like a permission can be given. It's also in a law. Suggestions can be given. Likewise, we can say that the command is not practically possible in modern world. In a democratic country, it is not. We cannot say that an order is a law, a command or an order is considered as a law. So that word command is not practically possible in modern world. And another criticism, that is, he completely ignored judge-made laws. So he didn't consider judge-made laws as a source of laws. Judge-made laws, you know what, the precedents, the previous judgments of the court is actually considered as a source of laws in most of the countries. Most of the countries considered this as a source of law. Apart from legislation, this judgment laws actually a laws is actually a law. So these precedents considered as a source of law. But Austin says that this is not a law. Law is actually given by the supreme power, the sovereign. Any other orders, any other opinions are not considered as laws. That are just opinions that is not considered by that's not considered as laws. And the concept of sovereignty, it's not practically possible in modern times. Another important aspect of this definition is sovereignty. Sovereignty, according to his concept, sovereignty means a person, a supreme power held by a person or a body of persons. That what he tried to say as a sovereignty. But in the modern world, this is not also not possible because in India, India, the constitution of India is actually considered as the supreme law, and everything everything is under this supreme law, that is constitution. There is no sovereignty. The supreme law, the constitution is actually the supreme power lied on this constitution in India. So in modern world, according to Austin's theory, the sovereignty concept is not practically possible. An ethical and moral concept excluded. According to him, there are no such things existed because in law, in jurisprudence, there is not. We cannot say there are ethical or moral elements in laws. According to him, law is law. What the order is, or the command is law. Whether that may be an unethical order, that may be immoral one. So the order given by the command given by the sovereignty may be immoral, may be non-ethical, but that is law. Even though the order given by the sovereignty is immoral, that should be obeyed by the people because that is law. So that is main criticism leveled against Austin. And when we talk about Kelson is also one of the important thinker, jurist in the positive school or imperative school, a follower of Austin. But he tried to modify the theory of Austin. That was the main important thing you have to consider. That is, you should keep in mind that the Kelson tried to modify the theory given by Austin. According to Austin, there is a command, there is a sovereignty, there is a sanction behind it. These are the three important things propounded by Austin. But according to Kelson, the law, the study of law or the jurisprudence should be free from all kind of all other subjects like politics, philosophy, history. The law should be free from all other subjects, all other disciplines. According to Kelson, the jurisprudence, the study of law, should be free from all these subjects. It is purely based on, the jurisprudence should be purely based on the law. So he advocated a pure theory of law. So in the case of Austin, he found a mistake that Austin says that there is a sovereign. Okay, we can see that the subject political science, we can say that a political science involved in that type of definition, because sovereign. So the word sovereign came there, and we can say that the political science subject is engaged there. So in some cases like historical school, the subject history is also existed. But in Kelson's pure theory of law, there is no other subjects. He says that only one thing is there, grundno, that is the supreme law. Okay, so according to Kelson's theory, um, the key concepts of Kelson's theory that there is a ground norm and there are some norms after that. So the ground norm is the supreme law according to his concept. In India, we can say that our ground norm is constitution. Okay, and the ground norm is constitution, and different other laws made by the legislature is actually norms. So we have many laws. Those are norms, and the ground norm is the constitution. The constitution given the constitution recognized these other laws. So any law which cannot which should not violate the provisions of constitution. So we can say that the validity of any laws in India, any acts or laws in India is based on the provisions of constitution. So the validity of any laws in India determined by the constitution. So it is very clear that constitution is the ground norm in India, and other norms we can say other laws created by our parliament. So ground norm is there and other norms are there. So this is the basic concept of Kelson's theory. And according to Kelson, Kelson says that we can the interpretation can be done in two ways. The first one is we can interpret the things based on our emotions, our beliefs. Okay, that is subjective in nature. That means we can interpret a thing, we can interpret an act based on our emotion, based on our beliefs. We can call it as a subjective interpretation. That is, we given the meaning to a particular thing based on our emotion. So that in that we actually given the meaning. That is a subjective meaning. Okay. And another possible thing is that we can interpret the things based on some norms. Based on some norms. Norms means there are some standard is already fixed, and we can given the meaning based on that norm. That should be objective in nature. That means that is not based on our beliefs. That based on some kind of norms. So that is objective in nature. So according to Kelson, we can given meaning to a particular thing in two ways. Based on our emotion, that is subjective meaning, and based on a norm, that is objective meaning. So Kelson says that jurisprudence is actually based on this objective meaning, given objective meaning to anything. So that is norms should be there. So there should be norms. We can given meaning based on that norms. It is objective in nature. So that's what he advocated. That is, some norms should be there, and above all norms there should be a ground norm. And ground norm is the supreme law, and the ground norm will given meaning to all kind of laws, and that are norms. Okay, these are the basic concept of Kelson's pure theory. And I already told you that the modification of Austin's command theory is actually the Kelson's pure theory of law. In Austin's theory, sovereign is the supreme power. But in the case of Kelson says that there are no such person is existed. Only ground norm is the supreme power, and the power lies on this ground norm. Ground norm will give validity to all other norms. No person is considered as a sovereign in Kelson's pure theory of law. So actually, Kelson tried to overcome the drawback of Austin's theory. And when we conclude, we can say that these two theories are play an important role in the formulation of a positive school. But pure theory of law is somewhat uh, have some more significant role. I have to say the pure theory of law is much broader one apart from that. And so we can say that these two theory are very important in the study of positive school.